So hello everybody, you're very welcome back to Law Hero. My name is Jen and I make videos about the law and other things. And today we're talking about EU law from the March 2025 paper. And yeah, we're going to go down through all of the questions, see what happened. So if you're looking for notes for the EU law paper, they're available on my website, lawhero.eu. And if you're looking for some daily inspiration on Instagram, it's at lawheroirl. So the first question, question 1, is a scenario involving a fictional EU directive on gambling. And it's a classic problem question testing direct effect and state liability. So Billy is a heavy gambler who lost over €4,000 betting online and in shops around May 2024. He only finds out later about this directive that limits daily betting to €500 and places a 10% levy on bets over €200. Now, even though Ireland passed laws to implement the directive, the changes won't kick in until August 2025. So Billy wants to take an action, and the examiner wants you to explain whether he can do that under EU law. So what should jump out at you here is the following. Firstly, direct effect of directives. Don't forget that they only apply vertically and only if they are clear, precise and unconditional. But crucially, the deadline for implementation was December 2023 and Billy's betting spree was in May 2024. So the implementation date has passed, and indeed they're not going to bring it in till August 2025. So then you have to look at penalising Ireland, state liability. So we go back to the principles of Frankovich and Brasserie du Péché. Was there a serious breach and did it cause Billy loss? So you want to walk the examiner through all of that, identify who the directive was aimed at. You would look at whether the betting shop is an emanation of the state and whether Billy can claim directly against the Irish state. Okay, so we're moving on to question 2. This question is more theoretical and focuses on the evolution of human rights, protections in EU law. It's a question that's asked year on year. In this question, you're asked to explain how the status of human rights has changed since the 1950s and how the Charter of Fundamental Rights is now the key standard. So the structure here is straightforward. You would start with how rights were originally developed through case law, like Stoddard and Nold. Then you would mention Article 6 of the TU and the Charter becoming binding under the Lisbon Treaty in 2009. And then you would discuss how the Charter is now used in CJEU case law, for example, Digital Rights Ireland Commission v Hungary, or even recent migration or surveillance decisions. So like anything, the rights have gone from being implicit to codified to enforceable. Don't forget to mention the role of the general principles of EU law and how national legislation falling within the scope of EU law must respect these rights. Particularly equality and discrimination legislation around employment law in Ireland is a big area for that. Question 3 is about EU legislative process, a question that's asked every year as well. So in this question, you're asked to outline the roles of the European Parliament, the European Commission, and the European Council when it comes to legislative, delegated, and implementing acts. So in this question, you would begin with the OLP, the Ordinary Legislative Procedure introduced by Lisbon under Articles 289 and 294 of the TFEU. You would then talk about how the European Parliament and European Council are co-legislators and how the European Commission proposes legislation as the legislative procedure. Then you would talk about delegated acts under Article 290 TFEU, which is used for non-essential elements, and implementing acts under Article 291 TFEU, where comitology comes into play. For case law, you would use examples like Germany v. Parliament and Council Tobacco Advertising, where the legal basis of a directive was challenged. Finally, you would assess whether the Lisbon Treaty improved the democratic legitimacy of the EU, maybe referred to the growing power of the European Parliament and the issue of the so-called democratic deficit. Question 4 is another problem question, and it related to free movement of persons and EU citizenship rights. This question comes up every year without fail. You can be guaranteed that it is a question that will be asked. So in this paper we meet Nora, a Belgian national who moved from the UK to Ireland post-Brexit and is now struggling to qualify for university fee waiver and grant. She's working part-time at minimum wage but doesn't earn over 26,000 a year. This question is full of facts. You need to examine whether she qualifies as a worker under Article 45 TFEU. Remember that part-time workers can be workers if their work is genuine and effective, and this was seen in Levin and Kempf. If she is not deemed a worker, she can rely on citizenship rights under Article 21 of the TFEU, and you would look at cases like Greslek and Bidar. The question of whether Ireland can restrict access to social advantages to EU nationals is based on proportionality and financial sustainability. So you'd need to advise her on both her position as a worker and as a citizen here. Question 5 is a classic free movement of goods question, and it relates to two companies who are worried about a proposed Irish environmental measure. One manufactures soap from imported petroleum, the other sells electric vehicles. The new proposals would add a charge of 50 cents per kilo on petroleum-based soap, but reduce the charge of rapeseed oil-based soap. It would also seek to ban the use of car chargers that rely on fossil fuel-generated electricity. Your job here is to assess these proposals under Articles 34, 35 and 36 TFU, and of course Article 110 TFU. For SUDS Limited, you're analysing discriminatory internal taxation under Article 1110 TFU. Is there a tax advantage for domestic products here? And when it comes to Italy City SPA, this is about quantitative restrictions or measures having equivalent effect, MEQR, under Article 34 TFU. Is the proposal a restriction on market access? So you'd look at cases like Dassonville, Cassis de Dijon, Commission v Ireland around Buy Irish, and Keck. So question 6 is a judicial review question from Article 2634 TFEU, and the standing or locus standi of non-privileged applicants gets asked year on year. The examiner asks whether it's now easier for individuals or companies to challenge EU acts than it was when A.G. Jacobs gave his famous opinion in UPA. So your structure would begin with the Ploughman case, where the test for individual concern was set very high. And then you would mention how later cases tried to soften that, like Cordino, Jago Kera and Greenpeace. You would note that regulatory acts with no implementing measures were added post-Lisbon, which makes the standing requirement slightly more relaxed. And you'd want to end with some analysis that, okay, there has been progress, but arguably it's still too narrow and the burden on applicants remains very high. Question 7 is more than likely the case law question. And I always say, don't bother with this. It's basically 3 out of 8 you'd have to do. I mean, here there was Costa v Enel. That's a supremacy question, so some people would have known that, but I don't think to the level that you're required in the FE1. So like I say in constitutional law, just avoid the case law question. Question 8 then is Article 106 TFEU competition law question. In this question, you're being asked to assess how and when public undertakings or those delivering services of general economic interest, SGEI, can be exempt from Article 101 and 102 TFEU. It's quite technical, but a good approach would be start by stating what the default rule is. EU competition law applies to undertakings, basically. Then you would explain how Article 106.2 offers a narrow carve-out for SGEIs only if the rules would obstruct their task. So you use cases like Albany, Corbeau and Deutsche Post. You should also touch on how the Commission and Court interpret this narrowly. The exemption is not a free pass. Think proportionality and necessity, two of the key principles of EU law. So I hope you enjoyed that video. EU law is very straightforward. There's never any surprises. You're always guaranteed basically all of the questions that were asked. I have never seen failure in the EU paper. It is a wonderful, wonderful paper to pass and a good one to start with. And I'll see you in the next one. Thanks for watching.